Okay, ma'am, we are live on YouTube. Please proceed.
A very good afternoon to everyone present here. I am Diksha Kuchya, a student of third year in LLB Honours, and I am the host for today's session. I welcome you all to the another lecture series organized by Department of Law, Prestige Institute of Management and Research. We have among us Ms. Rupam Deep Sahani, ma'am. Welcome, ma'am.
Thank you.
Ma'am is a managing partner of Rupam Deep Sahani and Associates. She is an accredited civil as well as commercial mediator and also has been in legal profession since 2014. She has completed her graduation in BCom LLB Honours from Amity Law College and also holds a master degree in International Dispute Resolution from Helmholtz University, Berlin. Ma'am, core practice area includes arbitration and litigation of criminal, civil and family disputes, real estates, construction disputes, engineering disputes, and maritime disputes. She is also formally associated with the Chambers of Justice S.K. Mishra, a former judge of Delhi High Court and a sole arbitrator. We are honored to have you here, ma'am.
Thank you.
We have among us Dr. Gopal Kag sir, Assistant Professor in Department of Law, and Mr. Shubhang Khare sir, Assistant Placement Officer at Training and Placement Cell as a faculty coordinator for today's lecture series. We are very honored to have you here, sir. If you had any questions and queries, you may raise your hand and we shall recognize you and unmute you. Else, you may write your questions in the chat box. And I request all of you to kindly switch on your videos.
They'll not be able to switch on their videos because we're on a webinar platform, but they'll be given the right to speak at the end, and you can give them yourself the right to speak because ma'am is the co-host. And
Okay.
I now request ma'am to kindly proceed with the session. Thank you so much.
Okay. Hi,
Over to you, ma'am.
Thank you, Diksha. Thank you for such a warm introduction. Hello, everybody. First, I'll just quickly share. Okay, 1 second. I think it's not visible.
Do you want me to be the host, ma'am?
No, actually, I lost the screen somewhere. Yeah, now we are here. Hello, everybody. As Diksha said, thank you, Diksha, for such a good introduction. And I'm honored to be here with all of you to discuss the Unit 2 for your curriculum in these lecture series organized by the Prestige University. And I'm honored to be speaking today. Now, if you have any question, I think we can take those questions at the end and we can continue. You can also write it in the chat box, which Diksha can take up with me at the end. And also, if I'm audible and if at any time I'm not audible, please let me know so that there is no hindrance in understanding. So let's begin if everybody is here.
Sure, ma'am. Sure, ma'am.
Okay. Now, since we are discussing the Unit 2, we start with the appointment of the arbitrator. And I believe that you guys have already studied in your Unit 1 the composition of tribunal. Now, once we have the tribunal, what is the next procedure is Section 11 of the Arbitration Act defines the appointment procedure, appointment of an arbitrator. If you do not have your Bare Act, don't worry, just focus on the presentation, focus on the screen, and I assure you'll be able to understand. Now, Section 11 just defines the procedure for appointment of arbitrator, either through an agreement between the parties or through court. Let's read what section subclause 1 says. A person of any nationality may be an arbitrator unless otherwise agreed by the parties. Subject to subsection 6, the parties are free to agree on a procedure. Now, oh, I'm so sorry. What this really means is that you can agree for an arbitrator from any nationality, whether an Indian, American, European, if the parties have not specifically agreed on a specific arbitrator having a specific nationality. In domestic arbitrations, generally arbitrators and parties are from common nationality, but in international arbitration, the arbitrator is generally from a third nationality. This is basically done to avoid the biasness or impartiality, to ensure that the arbitrator is not impartial. So there are disputes where parties are from two different countries. So the court makes it a point that, or the arbitral institution makes it a point that the arbitrator is from a third nationality, so that the biasness is intact. Subclause 2 says that parties are free to choose any procedure for appointment of arbitrator. Now, this is the beauty of arbitration, party autonomy. Parties are free to choose any procedure howsoever they would like to appoint the arbitrator, whether a sole arbitrator or a three-panel arbitrator. What happens when the parties do not agree? Now, failing any agreement referred to in subsection 2, in an arbitration with 3 arbitrators, each party shall appoint 1 arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator, who shall act the presiding officer. Basically, when the parties do not have a procedure in their agreement, then एक पार्टी अपना आर्बिट्रेटर अपॉइंट करता है, दूसरी पार्टी अपना आर्बिट्रेटर अपॉइंट करती है, and दोनों arbitrators then appoint the 3rd arbitrator, who is called the presiding officer. Now, if there is no procedure defined by the parties, then the common procedure is that the two parties appoint each party appoints their arbitrator, and then they appoint the presiding officer. Now, what happens when this procedure is not there? If one party fails to appoint the arbitrator within the given time, 30 days time is given to each party to appoint their arbitrator. When they fail to do that, or the 2 appointed arbitrators fail to appoint the presiding officer, then any party can make an application to the Supreme Court in case of an international arbitration, or the High Court of the state having jurisdiction in case of the domestic arbitration, and request the court to appoint an arbitrator in this case. The time period of 30 days is important. And if you can notice, it's written from the receipt of request to do so. Receipt of request is also very important. We are going to study further under section 21. What does this mean? But giving the notice of invoking the arbitration is very mandatory. Otherwise, the court will not have you accept your application for appointment of arbitrator. Now, this is the case when the parties fail to agree on a sole arbitrator or a 3-panel arbitrators. Now, even in the case of sole arbitrator, which is the subsection 5, which says failing any agreement referred to in subsection 2, which was the procedure agreed by the parties. In an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from the receipt of a request by one party from the other party to so agree, the appointment shall be made on an application of the party in accordance with the provisions contained in subsection 4, which means the same thing. If the parties do not agree on a sole arbitrator, then they can again apply to the court, and in case of international arbitration to the Supreme Court, and in case of domestic arbitration to the respective High Court. Or under the 2019 amendment, the power is now given to the arbitral institutions. Those are designated by the Supreme Court and the High Court to make the appointment of arbitrators. We are yet to see that happening, but the power will now be with the arbitral institution. So you have to make an application, a request for appointing the arbitrator to the courts or the arbitral institution. And now the subsection 6. What happens if this common procedure is not agreed by the parties? Now, This is one of another types of request that is made to the courts. There are three types of petitions under appointment of arbitrators, made to the courts. One is under subsection 4, under subsection 5, and another one is under subsection 6. Now, if the parties had agreed for a procedure, which we saw under subsection 2, but fails to act according to it, what does that mean? Now, for example, parties agreed for appointing an engineer as an arbitrator in their agreement, but now one of the party wants an architect as an arbitrator. He thinks architect has a better expertise on the issue at hand. Then that's a dispute between the parties now. In that case, or what is the second condition? When the parties or the arbitrators fail to reach an agreement expected under that procedure. Now, what does this mean? For example, the most common dispute that we see before the courts is regarding the fees of the arbitral tribunal. The parties want to pay according to the 4th schedule that is fixed by the Act, and the arbitrator says that he was appointed according to the ad hoc fees. Now, even for this kind of dispute, the parties can move under subsection 6 of section 11 and request the court that the court appoints the arbitrator. Third condition is that if any of them fails to perform their function, that is including the arbitral institution, if they fail to perform their function, I think it's just stopped. I don't know if you can hear me. Just let me know if you guys cannot hear me. In that case, you can request the court to appoint the arbitrator. Now, there are 2 new amendments under 2019 that has been introduced, that the designation of any person or institution by the Supreme Court, or as the case may be, the High Court, for the purposes of this section, shall not be regarded as a delegation of judicial power by the Supreme Court or the High Court. Now, next is once you file the request with the court to appoint the arbitrator on the party's behalf, whatever the court decides, whoever the court appoints or the arbitral institution appoints, is considered the final decision. And now under 2019 amendment, no appeal can lie against such a decision. एक बार कोर्ट ने arbitrator appoint कर दिया इस केस में, then इस appointment के against आप appeal नहीं कर सकते हैं. That appointment is final. अपॉइंटमेंट पिटिशन मूव करने के लिए अंडर सेक्शन 11 कैसे मूव करते हैं वो भी मैं आपको आगे बताऊंगी. सबसेक्शन 8 कहता है कि आर्बिट्रल इंस्टीट्यूशन रेफर टू इन सबसेक्शन 4, 5 and 6 बिफोर अपॉइंटिंग एन आर्बिट्रेटर shall seek a disclosure in writing. Now, the arbitrators are supposed to disclose under section 12 that we are going to discuss later, about their independence and their impartiality. Now, what happens is when you move a petition before the court for appointing the arbitrator, and the parties either have in their arbitration agreement that the arbitrator should have this qualification and should belong to this department or should be from this cadre, or sometimes the parties don't have. What happens is when you move the petition before the court is supposed to give due regard to these qualifications or the perspectives that the parties have agreed in their agreement. Any qualification that the parties have agreed, the court has to take into that into the regard before appointing the arbitrator for the parties. Otherwise, this particular thing can be challenged after the final award has been passed, for setting aside of the award. So the arbitrator has to give disclosure that he is independent and he is impartial. Now, in the case of appointment of a sole or a third arbitrator in an international commercial arbitration, the arbitral institution or the court may appoint an arbitrator of a nationality other than the nationalities of the party, which we already discussed that this is important to ensure the biasness or the impartiality and the independence of the arbitrator, so that he's not biased towards the party who belongs to his own nationality. Now, subsection 10 says that the Supreme Court, or as the case may be, the High Court may make such scheme as the court may deem appropriate. This is basically very procedural, that the Supreme Court and the High Court has made a particular performa scheme. You have to comply to that while making a petition to the court. Now, subsection 11 is very important. It says that if the parties have applied at different high courts in case of domestic arbitration, or to courts of different countries in case of international arbitration, or to different arbitral institutions, matlab, if the courts have applied to 2-3 high courts in India where they have assets or where they have their regional, or they've applied in case of an international arbitration, the parties have applied to the courts of, one party has applied to its court of the country and the other party is also applied to the court of its own country, or they have applied to the arbitral institutions of their own country, meaning hereby more than one petition is pending for appointment of the arbitration, then the Arbitration Act now very clearly says that the petition that was first made has the power to appoint the arbitrator in this case. अगर दिल्ली हाई कोर्ट में फर्स्ट पिटिशन आई थी, या मुंबई हाई कोर्ट में फर्स्ट पिटिशन आई थी, या मुंबई आर्बिट्रल इंस्टीट्यूशन में फर्स्ट पिटिशन आई थी, जिसके पास भी फर्स्ट पिटिशन गई थी, in case of multiple petitions, that has the power to appoint the arbitration. Now, this is one of the most common challenges before the court, as it indirectly leads to deciding on the jurisdiction of that court to entertain such a petition. अगर आर्बिट्रेशन क्लॉज के हिसाब से कोर्ट की ज्यूरिसडिक्शन नहीं है आर्बिट्रेशन में रेफर करने की, तो वो अपॉइंटमेंट पावर एक्सरसाइज नहीं कर सकता. That court does not have the jurisdiction or the power to then appoint the arbitrator. Now, where the matter referred to in subsection 4, 5, 6, and 8 that we had done, 4, 5, and 6 were the petitions before the court, the different circumstances where you can apply to the court. Arise in an international commercial arbitration or any other arbitration, the reference to the arbitral institution in those subsections shall be construed as reference to the arbitral institution. Now, this is a new amendment brought in by the 2019 Act, that like I told you, that now the appointment of arbitrator will be done by the arbitral institutions. So all these petitions for appointing the arbitrator shall be given the where the court has referred the matter for arbitration, it will automatically go to the institution that the court has designated. Also, that when the new amendment also has one more thing, that the High Court and the Supreme Court will designate the will select a panel of arbitrators under this arbitral institution who shall be appointed. Now, subsection 13 says that an application made under this section for appointment of an arbitrator or arbitrator shall be disposed of by arbitral institution within a period of 30 days from the date of service of notice on the opposite party. Now, what happens is, when in case of an arbitral institution or an institutional arbitration, you make a request for appointment of arbitration to the institution, and that the notice for that request is sent to the opposite party as well. Now, from the 30 days when the opposite party receives that notice, the institution has to dispose of this application. It has to appoint an arbitrator, or it has to terminate. When the court or the institution is taking is deciding on the application for appointment of the arbitrator, they always look into just one factor, which is the existence of the arbitration agreement. If they think that the arbitration agreement or the arbitration clause exist, then they refer the party. They are mandated under under section 8 of the Act to refer the parties to the to arbitration. Now, this is that disposal of application. Subsection 14 is easy, that the arbitral institution shall determine the fees of the tribunal and the manner of its payment to the tribunal. subject to the rate specified in 4th schedule. Now, the court has fixed a 4th schedule. The Act has a 4th schedule which has a fixed fee as per the claim amount, and the maximum cap is, I think, 30 lakhs. And but this 4th schedule is only applicable to domestic arbitrations, not in case of international arbitration. Even the parties in an international arbitration cannot, in their agreement, agree to 4th schedule. Otherwise, the agreement will, that part of the agreement will not be valid. So in domestic arbitrations, obviously the parties can take course to the 4th schedule of the Act, which fixes the fee, and they fix the cap of the fee payable to the arbitral institution. Now, but in just one thing, that in institutional arbitrations, the maximum fee goes up to 5 to 6 crores. So this, for fixing the 4th schedule, is very mandatory. It has helped the arbitration. And this was done in a case in 2017, actually, by the Delhi High Court in the case of NHAI versus Gayatri Roadways. The Delhi High Court had fixed that determination of the fees of the arbitration, or capping them, is very essential as compared to the ad hoc fees that was payable to the arbitrations. Now, just summing up section 11 for you. If the parties have agreed for a procedure for appointment, or they have agreed that they will have a sole arbitrator or a 3-member tribunal, then whatever the parties have agreed in their agreement, that is what takes precedence. Always remember, in arbitration, party autonomy takes precedence. Then, if the parties do not come to an agreement, they do not agree mutually towards any arbitrator or the procedure for appointment, they can always approach the court, or now the arbitral institutions, under subsection 4, 5, and 6, and they can make an application to the court, and the court can appoint the arbitrator for the parties. Only the court has to keep in mind the qualifications of the arbitrator that the parties have agreed to, and that the arbitrator is impartial and independent. And yes, the nationality of the arbitrator is important. In domestic arbitrations, we generally have the Indian nationality, but in the common nationality, but in international arbitrations, it is the third nationality. Now, we come to the next topic. Any questions you have regarding the appointment procedure or appointment of arbitrator, please note down. We can take it at the end. Now we come to the removal of arbitral tribunal. There are grounds for challenge under section 12 of the Act, through which an arbitrator can be removed, and under section 13, it's the procedure for removal. Now, let's understand these grounds for challenge. Now, appointment के समय हर arbitrator को 6th schedule of the Act में 6th schedule है. According to the 6th schedule, he has to give an undertaking that he is impartial and he is independent. मतलब arbitrator को दोनों parties से, उनके counsel से या dispute से कोई personal, professional, business relationship नहीं है, at least from the past 3 years. Also, and that the arbitrator does not have any personal interest in the final outcome of the dispute. मतलब कि अगर ये plaintiff के case में settle होता है या respondent के case में settle होता है, में कोई फायदा नहीं है. Arbitrator independent है and impartial है. If he is not independent and impartial, or if he has any relation to the parties or to the counsels of these parties, any kind of relationship, then that arbitrator is not considered as independent and impartial. Now, Schedule 5th and Schedule 7th, because we have quite less time syllabus to cover, so we cannot about the 5th and 7th schedule, but I would request all of you to study the 5th and 7th schedule of the Act. उसमें कुछ reasons दिए हुए हैं that under those reasons आप challenge कर सकते हो arbitrator को. Go study those reasons, and if you do not understand any of them or you have any query, ask me in tomorrow's lecture. But 5th and 7th schedule of the Act lays down the list of issues or grounds that can raise challenge for an arbitrator. Now, 5th schedule is basically in international arbitration, it is the IBA rules that govern the independence and impartiality of the arbitrator. Under the IBA rules, there is a list, red, orange, and green list. If the issue comes under the green list, that means the arbitrator is independent and impartial. He can be very well appointed, and there can be no challenge that can be accepted. If the matter is about the red list, that means the arbitrator is cannot be appointed, and that challenge needs to be accepted. And in case of an orange list, it is called as a justifiable doubt. Now, similarly, the Arbitration Act has adopted the 5th schedule and 7th schedule from that list of the IBA. Now, 5th schedule contains the grounds, the issues that are gives only a justifiable doubt that the arbitrator may be impartial. Let me give you an example of a justifiable doubt: that arbitrator holds shares in one of the companies, or he knows one of the relatives of any of the parties. That necessarily does not declare that the arbitrator is impartial. He might be and he might not be. So that is a justifiable doubt, and justifiable doubt is important to uphold the impartiality of the arbitrator. But in the 7th schedule, all issues under 7th schedule makes the arbitrator ineligible to be appointed. For example, if the arbitrator has very recently advised or represented any of the parties, or let's say the arbitrator is an employee or a counsel or an advisor of any of the parties currently, then he cannot be an arbitrator. Now, under 2019 amendment, again, a very new thing has been introduced, which gives party autonomy its wings. And it says that if the parties agree in writing, if they agree in writing to exclude the application of 7th schedule, then it will be excluded. अगर parties ने एक agreement कर लिया है कि ये 7th schedule के जितने भी issues हैं, ये हमारे case में apply नहीं होंगे, then any ineligibility of the arbitrator on the basis of 7th schedule will not be applicable in this case. A very important point is that any party may challenge this appointment of arbitration if these issues mentioned in both the schedules come to his knowledge after the appointment took place. Now, basically, what happens is that when the arbitrator is appointed and the parties have participated in the appointment of the arbitrator, but after the appointment, it comes to the knowledge of the party that no, this arbitrator is not independent, because I got to know that he has links with this counsel and he is linked with the relative of the parties. Then he can raise the issue for challenging. अगर पहले ही नॉलेज थी, आर्बिट्रेटर अपॉइंट करने से पहले नॉलेज थी और फिर भी अपॉइंट करा, देन ही कैन नॉट चैलेंज इट. बट आफ्टर अपॉइंटमेंट अगर उसके नॉलेज में आया दैट दिस इज द रीजन फॉर इम्पार्शियलिटी, देन ही कैन चैलेंज इट. अपॉइंटमेंट ऑफ आर्बिट्रेटर की तरह ही चैलेंजिंग प्रोसीजर जो है, दैट इज ऑल्सो वेरी सिमिलर. लेट्स अंडरस्टैंड व्हाट इज दिस चैलेंज प्रोसीजर. आई एम सो सॉरी. Yeah. Now, subject to subsection 4, the parties are free to agree on a procedure for challenging the arbitrator. Now, failing an agreement referred to in subsection 1, parties who intends to challenge an arbitrator shall, within 15 days after becoming aware of the constitution of the tribunal or after becoming aware of the circumstances referred to in subsection 3 of 12 that we just studied, send a written statement of the reasons for challenge. Now, after, like I told you, after he becomes aware of the challenge, he can make a written statement and he can inform the opposite party and he can inform the arbitrator that these are the reasons that he wants to, because of which he wants to challenge this particular appointment. And he can only make this challenge within the 15 days from the day he became aware of it. And what happens is, unless there are two situations. One is that either the arbitrator withdraws himself, or the other party agrees that yes, this challenge shall subsist and they're right, he can be impartial or independent. Now in that case, the arbitrator is removed, or he's terminated, or he's substituted by another arbitrator. But if the arbitrator does not he thinks that no, these challenges are not right, and let's read subsection 4 says, if a challenge under any procedure agreed upon by the parties or under the procedure under subsection 2 is not successful, then if he arbitrator shall have the jurisdiction to decide this challenge. This we will study under section 16. And he decides that no, these challenges are not correct, and he satisfies the parties that he does not have any such relationships or whatever the issue would be at hand, then the proceedings will continue, the tribunal will continue, and the tribunal will make the award. Even after the tribunal has made this decision that this tribunal is not independent, is independent and impartial, and they're not biased, and one of the parties is not satisfied, उन्हें लगता है कि नहीं ये this is still, he's still independent, and he's still partial towards that party, he's not independent, then this challenge can only and only be taken at the time of setting aside the award. It cannot be raised before that. It cannot be raised during the arbitral proceedings. In the previous 1940 Act, this was there that the parties could take up to the court any time between the arbitral proceedings, and this way the proceedings used to never end. But now, especially with the 2019 amendment, it has become very clear that once the tribunal has decided, has taken jurisdiction, has entered appointment, and has made a final decision about it, you can only take these challenges at the time of setting aside the award, not before it. That is what the subsection 6 is, where an arbitral award is set aside on an application made under subsection 5. The court may decide as to whether the arbitrator whose challenge is entitled to any fees, meaning hereby when the party takes it to the court at the time of setting aside, and the court decides in the favor of the party and against the arbitrator, then the court has the power to take the fee back that was paid to the arbitrator, because that's not right. And the Act is very clear on it. Now, what happens in the case of failure or impossibility? Sorry. The mandate of an arbitrator, I don't know, okay. The mandate of an arbitrator shall terminate, and he shall be substituted by another arbitrator in two conditions. One is that he becomes de jure or de facto unable to perform his functions, or other reasons fails to act without undue delay. Now, de jure is means due to the law, and de facto means due to the facts. If he becomes legally incapable of performing his functions, for example, he becomes he's incapacitated, becomes due to criminal conviction, for example, he's criminally convicted, then he cannot now act as an arbitrator. Then he turns out to be one of the close allies of the counsel of the arbitrator, one of the parties, then he cannot perform, or he cannot continue as an arbitrator. Similarly, if the facts of the case make him, facts of the proceedings make him incapable of performing his functions, then also he shall be, the mandate of the arbitrator shall terminate. And now the facts are basically, if the arbitrator dies, then, or he becomes seriously ill, that he is not able to, act as an arbitrator. In that case, his mandate will be terminated, and he will be substituted by another arbitrator. Now, and obviously, if the arbitrator voluntarily withdraws from his office, or the parties agree that his mandate should be terminated, like I told you, nothing supersedes the party autonomy, then also the present arbitrator shall be removed, and he shall be substituted by a new arbitrator. Now, subsection 2 says that if a controversy remains concerning any of the grounds referred to in clause A of subsection 1, a party may, unless otherwise agreed by by the parties apply to the court to decide on the termination of the mandate. Now, this happens mostly in the cases when the arbitrator becomes legally incapable of performing his functions as an arbitrator. Then he does not kind of agree that he mandates, like so the parties under subsection 2 can move, of section 14 can move before the court to decide on this termination of the mandate. Now, if under this subsection, the arbitrator, or under section 13, subsection 3, an arbitrator withdraws from his office or a party agrees to the termination, it shall not imply that the acceptance of the validity of any ground referred to in this subsection or subsection 3 of section 12. Now, what happens? What is the the termination and the mandate? We've discussed that when he dies, the section 15. This is section given in the section 15 of the Act. Section 15 is an extension of section 14 that we've just studied. That mandate of an arbitrator will also terminate if he withdraws from his office or the parties agree to terminate the arbitrator. Also, one thing is important, that the substituted arbitrator will take over the proceedings of the previous arbitrator, but all the orders that have been passed, the interim orders or other orders that have been passed by the previous arbitrator, that remains valid. So he can be replaced by the new arbitrator. Now, this is more or less the same. Now, this was about the arbitrator and his appointment and removal. Next, we come to the jurisdiction of arbitral tribunals. The arbitral tribunal is competent enough to rule on its own jurisdiction. That is the settled law, and it is called the principle of competence that we have taken from the German law. What does this mean? Now, before this 1996 amendment had come, there was no such doctrine of competence, and the arbitral tribunals could not, rule on its own jurisdiction. It was only the courts who could rule whether the arbitral tribunal has a jurisdiction or does not have a jurisdiction, or whether the validity of the arbitration agreement or the clause is valid or it's not valid. Everything was decided by the court. Only after the 96 amendment, this the rule of competence and the doctrine of severability was introduced, and the power was given to the arbitral tribunal. Now, what does this mean, that the arbitral tribunal has the power to rule on its jurisdiction? It means that the arbitral tribunal has the power to decide all issues of existence and validity of arbitration agreement and related objections, and whether it shall exercise the jurisdiction over the dispute or not. There are three things that the arbitral tribunal can rule over its rule on its own, has the power to rule under competence, and that is whether the arbitration agreement is existing or not, whether the arbitration agreement is valid, whether it has the jurisdiction over the dispute, the issues at hand or not. Now, the arbitrator derives the power to rule on its own jurisdiction from the arbitration agreement or the arbitration clause. Once the parties have entered into an arbitration agreement or they have an arbitration clause in their agreement, that means that the court has to refer the parties to the arbitration. Now, the arbitration can rule on its jurisdiction. Just by that clause, the arbitrator derives its power by the principle of competence, that it can rule. It can decide that yes, this is valid, or yes, this is existing, or no, it is not. Now, this is one reason that why arbitration agreement is treated separately and independent from the main contract. that is based on the doctrine of separability, or some people say severability also. It means that even if the contract is null and void, the arbitration clause or the arbitration agreement is separate, independent, and valid. It will still be valid, it will still be decided. Now, invalidity of the contract does not render the arbitration clause invalid. Okay, sorry, my screen is never. Can somebody please tell me in the chat if they can hear me? Because something has stopped for me here.
Yes, ma'am, we can hear you.
Okay, thank you so much. Okay, now under the severability, the arbitral tribunal has always treats the agreement as separate, even if it decides that the main contract is invalid or it's null and void. The arbitration agreement is still valid, and it decides on the arbitration agreement, and it continues the proceedings on the basis of that agreement. Now, earlier there was no such power, like I told you. With the tribunal, these issues were only to be dealt by the court. Now, once the arbitration is referred, the court refers it to arbitration, the parties are referred to arbitration, the power comes to the arbitrator. Now, when can you make this challenge of jurisdiction? Whenever the respondent makes the challenge of the jurisdiction of the tribunal under Section 16, he has to do so along with his statement of defense when he is filing his statement of defense, not later than that, because then it could be treated as a strategic move to either delay the proceedings or to not pay his claims. But once he files, if he's filing his statement of defense to rebut the claimant's claim, then he also has to challenge the jurisdiction then only if he thinks the tribunal does not have jurisdiction. Later, the tribunal will not entertain. Although there is one exception to it, and that is that even if the respondent gave his consent earlier that while appointing or nominating the arbitrator, it does not mean that he cannot he cannot raise these challenges under Section 16. He might have given his consent for appointing the particular arbitrator, but he can later on raise the issue of jurisdiction, because that might have come to his knowledge only after he read the claim of the petitioner, that, oh, this particular arbitrator does not have jurisdiction, because the arbitration in itself is not the right course of action. The right course of action could be to approach a particular tribunal. Now, what happens now when the arbitrator, you can also raise the issue of challenging the jurisdiction when the arbitrator acts beyond its scope. Then also you can file an application under Section 16. The arbitrator, by the virtue of the powers given to him under the Act, can only arbitrate on the issues that are the subject matter of the dispute. Now, basically, जब एक arbitrator appoint होता है, उसके पास power इस act के अंदर इतनी ही है कि वो उन्हीं matters पर अपना decision दे सकता है जो issue subject matter. First, obviously, arbitrable है. It cannot be a non-arbitrable issue like a dispute of a public nature. But if the subject matter in hand, if the issues in hand between the parties, the dispute, he can only exercise his powers over them. If he tries to move beyond those issues, then he is moving beyond the scope. Then he is moving beyond his jurisdiction. That can also be challenged under Section 16. I think subclause 3, that is. So all the issues that are pleaded, the claims that are raised, only you have the power, the arbitrator has the power, the tribunal has the power to exercise jurisdiction on them, not beyond or outside them. Obviously, this kind of issue that the tribunal is acting beyond its scope, is acting beyond its power, can be raised anytime during the proceeding. It is not necessary to raise when you, at the time when you file your pleadings, because this has to be raised as and when it is brought to your knowledge during the proceedings. Now, if there is a justified delay in raising, there is the Act now gives this kind of condonation. I'll say that when if there is a justified delay in raising an objection for challenging the party or making the application under Section 16 on time, that delay can always be condoned. And for a very good example is of a justified delay is the present pandemic. If due to the present pandemic there was no virtual hearing taking place, no physical hearing was taking place, and there was a miscommunication, the party got to know late about an issue that it thinks can be challenged before the tribunal under Section 16, it can do so even late, and that can be condoned. But otherwise, the challenge for jurisdiction has to be done while filing your statement of defense, and for acting beyond its scope can be done later also. Now, what happens procedurally is that in these applications, Section 16 applications, that respondent files his statement of defense, and along with it, he files the Section 16 application challenging the jurisdiction of the arbitrator. The arbitrator first deals with the Section 16 application. He first decides whether he has jurisdiction or not, and then based on that decision, he either terminates himself or moves, or the proceeding moves forward. If he thinks he has jurisdiction, he continues with the proceedings and gives an award. Now, again, like we had discussed earlier, at the time of impartiality and independence, अगर respondent को लगता है that he is not satisfied कि arbitrator ने बोला है उसकी jurisdiction है, but उसकी jurisdiction नहीं है, then he cannot challenge that at the same time before the court, but he can challenge this particular time. He can take the challenge of the jurisdiction of the tribunal under while setting aside of the award under Section 34, not before it. Now, we will discuss that later, but the point to understand here is that if only the arbitral tribunal will have the power to decide whether he has jurisdiction or not. If he has decided that yes, he has jurisdiction, then that can be challenged only at the time of setting aside the award and not before it. Now, during the pendency of the proceedings, you cannot take it. Only you can take it later, that the arbitrator has acted, beyond its jurisdiction and still given the award. So this award should be set aside. So we come to the last topic for today, and that is the interim measures by arbitral tribunal. A very interesting topic, also a little tricky, because we also have interim measures under Section 9, which I suppose you guys have studied. That is, those measures are given by the court. And these are Section 17 interim measures that are given by the arbitral tribunal. Basically, the power under Section 17 is not as wide as under Section 9 with the court. But now with the Delhi High Court judgment in the case of Shri Krishna versus Anand, the court has held that, if a party makes a contempt, does not obey the interim measures of the tribunal, then that would be treated as a contempt of the court, as the tribunal can make this representation to the court about it, and the court will treat it as the civil contempt and deal it accordingly. So Section 17 is also pretty new. These interim measures are also pretty new. Earlier, you could have only approached the court for getting these interim orders, but now the arbitral tribunal can also give these interim orders, and they are enforceable. Under Section 17, you make an application before the tribunal, and either party can make that application to the tribunal for securing interim measures. Then after, obviously, application under section 17 will always be moved before the tribunal after the tribunal is constituted, but before the award is passed. So before मतलब आपके tribunal के बनने से पहले आपके पास आर्बिट्रेटर नहीं है टू फाइल एन एप्लीकेशन, एंड अगर अवार्ड पास हो गया है तो फाइनल डिक्री आ गई है, एंट्रिम मेजर्स नहीं मिल सकते. सो एंट्रिम मेजर्स की एप्लीकेशन ट्राइब्यूनल कॉन्स्टिट्यूट के इमीडिएटली बाद से लेकर फाइनल अवार्ड पास होने तक कोई भी पार्टी कभी भी सेक्शन 17 के अंडर फाइल कर सकती है. What are the matters in which these interim measures can be granted by the tribunal? These are preservation, interim custody, or sale of any goods which are the subject matter of the arbitration agreement. मतलब कि to take the custody or put a stay on the goods so that the other party does not sell it. Then securing the amount in dispute in the arbitration so that the parties do not sell their assets. Detention, preservation, or inspection of any property or thing which is the subject matter of dispute in arbitration. This is very similar to a section 9 measure, or as to which any question may arise therein, and authorizing for any of the aforesaid purposes any person to enter upon any land or building in the possession of party, authorizing any samples to be taken, experiment to be tried, or which is, important for the purpose of taking evidence or getting the full knowledge. So the arbitrator does have that kind of power now to give to the parties. Then obviously interim injunction or appointment of a receiver, if the case may be, and any protection measures that the tribunal thinks is just, it can give to the parties. And now these orders will they can be enforced like a civil court, and they can be enforced like decrees. They can be before the court. Now, interim measures issued by the tribunal has the same power that of the civil code, and it should be valid until the termination of the arbitral proceedings or passing the final award. Till the time the final award is not there, these interim measures by the tribunal will remain and they will be valid. Obviously, this gives the tribunal much more teeth. Like I told you before amendment, the tribunal did not have any such power to pass any orders, and even if they had passed any orders, they were not ever implemented because they were not considered at par with the court orders. I think the idea of introducing section 17 is obviously to save time and burden on the courts and smooth functioning of the arbitral proceedings. Normally what used to happen that parties would approach the court first for challenging the jurisdiction of the arbitrator, then for securing interim measures, then for any independence or impartiality. All this used to take about 4 to 5 years, even before the arbitral proceeding could commence. So the arbitration would, lose its essence as a dispute regulation mechanism because the litigation before the pre-arbitral litigation was never ending, or sometimes these litigations used to go in the middle of the arbitration proceedings and there was a stay. But now with the new amendments, the arbitral tribunals have been given a real power, and the arbitrator is given a real power like that of a judge, of a court, of a civil court, and he can decide on its jurisdiction. He can also give interim orders, and he can also decide whether he should be on the panel or he should be removed. Even after the amendment, there were cases where the tribunals had given the interim orders, but they were not recognized because the court did not recognize such. A very landmark judgment on that was Sundaram Finance versus NEPC. If you want to read, in that the court did not recognize the interim measures that were given by the arbitral tribunal, and it said it cannot be at par with the court. But like I told you, in the matter of Shri Krishna versus Anand, the court said no, the arbitral tribunal has the power, and those orders, interim measures that the tribunal will give, those will have the power of a civil court, and if you do not obey them, then you will have contempt of court. So that's about the interim measures, and we come to the end of today's lecture. If you have any queries or questions, you can always contact me on LinkedIn, and you can even email me on this link. And of course, we will take your questions now during the live session. Thank you so much for being here with us. And tomorrow we will discuss how to conduct the arbitral proceedings. Now, there's another thing that I would really appreciate if you could give me a little feedback of today's lecture, so that I know it's very what you understood, what you did not understood, what you liked, what you did not like. Be very open and honest, because we're all here to learn, and that is the reason of this lecture. So give me a little feedback if you can, or you can give it to Diksha, who can communicate it to me. And for the next 2 days lecture, we can modify it accordingly. Thank you. Over to you, Diksha.
Thank you, ma'am. It was such an informative and knowledgeable lecture.
Thank you.
Now we are open for taking question and answer. I request all of you to, if you had any queries, you may raise your hand and we shall recognize you and unmute you. Else, you may write your questions in the chat box. Ma'am, there is one question from the student.
Yeah.
Shall I proceed?
Yes, please.
Ma'am, the question is whether the right of one party to appoint an arbitrator stand extinguished by virtue of the amended section 12 of the Act.
No, so the right of appointment will not be extinguished under section 12, because okay, let's understand that where the parties get the right to appoint the arbitrator, he gets the right under section 11, and he gets the right from his arbitration agreement. His arbitration agreement says that both the parties have a clause saying that a sole arbitrator will be there, or 3-member tribunal will be there. So he gets a right from his clause that yes, this he can appoint a sole arbitrator, he can nominate his arbitrator, he can nominate agree mutually on a sole arbitrator or 3-member. The section 12 is basically on the impartiality and independence of the arbitrator. So after the arbitrator is appointed, then the section 12 comes into the picture, that whether this arbitrator can be or cannot be impartial or independent. But there is one thing, that when the arbitrator is appointed by the court under section 11, subsection 4, 5 or 6, the court looks into the section 12, the court looks into the impartiality and independence of the arbitrator. And if the court finds that he is, then the court appoints it. But if it finds that the arbitrator is not independent and he's partial, he's biased, then he has to be terminated. But the right of the party to appoint an arbitrator only comes from his clause, his arbitration agreement. And yes, those are the rights that he has to appoint an arbitrator.
Okay, ma'am. Ma'am, there is a second question. When the participation of appellants in the arbitration proceeding can be treated as implied consent for an extension?
Okay, so we have not discussed extension as of now. The rule with the extension is that implied consent can be, sorry, can you just repeat the question again?
Sure, ma'am. When the participation of appellants in the arbitration...
Okay, yeah. Yes, please continue, Diksha.
In the arbitration proceedings can be treated as implied consent for an extension.
No, so it cannot be implied consent as such, because if you have the arbitration, I mean, I don't know what do you mean by appellant, because in case there is an already challenge going on before the court, by that you mean appellant, then there is a stay, and that is an implied consent as long as the matter is before the court and there is a stay on the arbitration proceedings, the matter will be extended. However, now under section 29A, the parties have to give their consent, that cannot be implied, to extend the proceedings, to extend the time of the proceedings. Only if the proceedings are pending before the court, it can be extended, but it has to be brought into the notice of the court that 1 year has been lapsed, because after 1 year and then 6 months more, after 18 months, implied consent will not work. Express consent has to come, mutual agreement of the parties has to be there. Only then the proceeding can be, or the mandate of the arbitrator can be extended. Otherwise, it will be terminated, and a fresh arbitrator will be appointed.
Okay, ma'am. Ma'am, there is another question from Vandita Singh. She is
Yeah.
asking, when the parties, what are the consequences if one alleged other of fraud, whether it can render the arbitration agreement void?
Sorry, what happens in, I can't understand your question. Can you come again?
What are the consequences if one alleged other of fraud in arbitration, whether it can render the arbitration agreement void?
So one thing, okay, I was under the impression that you have studied Unit 1, whereas what disputes are arbitrable and what are not arbitrable. Criminal offenses are not arbitrable disputes. Fraud is a criminal offense, and if we are talking about Section 420 fraud, or I don't know what fraud you're talking about, but any criminal fraud or any criminal offense cannot be arbitrated, and it's not arbitrable. So in that case, you cannot have an arbitration clause, that will be invalid. But if you mean that when you have an arbitration clause and you make a fraud statement, or you make a fraud claim, in that case, no, the arbitration clause will not be invalid, but the claim of the party will be denied. But any kind of criminal section or any kind of criminal act cannot be arbitrated. It has to be dealt by the courts.
Okay, ma'am. Ma'am, there is one question from Sarvangi. She is asking.
Okay, I think it's in the chat. Can I read it? If one
Yes, ma'am,
party
you
is
can.
from India, other are from foreign country, and both filed suit in their respective country for appointment of arbitrator, then what will happen? Which court decides and supersedes? Okay, Sarvangi, very good question. But like we had discussed that if one party is from India and the other party is from a foreign country, that means it's an international arbitration. Now, in an international arbitration, if the plaintiff has filed, let's say, in the Supreme Court of India, and the respondent has filed for the appointment in the court of its own country, then whichever court receives the appointment application first, that court will have the power to decide the appointment of the arbitrator, and that will be valid, and that would also be final.
I hope, Sarvangi, you get the answer.
Yes, guys, if there is anything not clear or still have a question, please be free to ask. And obviously, you can ask me 10 more times.
Thank you, Sarvangi. Ma'am, the next question is, how long does the arbitration last?
Now, that is I'll say a good question, but there is no such time. There is no such time for an arbitration to last, because with the earlier amendments, the arbitrations used to go on forever like litigation. With the new 2019 amendments that we see a ray of hope that the arbitrations are going to end sooner, and within 18 months of time that the court has, that the Act has already given. The Act says that within 18 months, the award shall be given, and we are expecting with amendments like the jurisdiction and not, the courts not entertaining so much interference, the courts not having so much judicial interference, or the courts are giving the power to the tribunal Also, when the institutionalization of the Indian arbitration, that step is going to bring, I think, a lot of respite to the arbitration community in India, because that may help us in deciding the matters fast. But as of now, in my experience, arbitrations do go on at least for 2 years or 3 years. But there is an exception. In case of fast track arbitration, the arbitration has to be decided within 6 months when it happens. That is under Section 29B. And the requisite for it is that you have to include the fast track clause in your agreement. Then you can have a fast track arbitration and you can decide it within 6 months. And otherwise, you have to decide it within 18 months. So 18 months time is there, and some more time goes thereby in evidence and all, practically. But there are cases, like I was dealing with one property matter, which was a very simple matter. So we were able to secure our award within a year, within 12 months. And that was, I think, the biggest win in my career of arbitration, that we got an award for a client within a year. But usually it takes time. But now with the 19th Amendment and institutionalization approach, we hope that it's going to take lesser and lesser time.
Okay, ma'am. Ma'am, there is one question from my side.
Yes.
Ma'am, what happens if it alleged that the arbitrator had no jurisdiction?
So if the arbitrator decides himself that he does not have a jurisdiction on the dispute in hand, on the subject issues, the subject matter in the issues, then he has to terminate himself. He has to terminate his mandate. He has to withdraw himself from the arbitration, and a fresh arbitrator needs to be appointed. And in that case, we come back to the same provision. Either the parties will appoint the arbitrator according to the agreement that they had entered into. They have if they have in their agreement already decided the procedure for appointment, then they will appoint a fresh arbitrator according to that that procedure, sorry. And otherwise, they will then again approach the court, and the court will again appoint a fresh arbitrator for them, who will now have the jurisdiction.
Okay, ma'am. Ma'am, the next question is from Samriddhi. She's
Yes.
asked, if the arbitration agreement remains valid even though the main content get void?
Yes, so this is the doctrine of severability that we were discussing, that the arbitration agreement is independent and separate from the main contract. Is void, null and void, incapable of performance, or invalid, even then the arbitration clause in the arbitration agreement stays it stays valid, and it can always be capable of being performed and operated.
Hope, Samriddhi, you get your answer. Ma'am, the last question is, what can be done if one party ignores the arbitrator agreement and commences court proceedings?
Oh, I'm not sure I understand that question. Ignores the arbitration agreement, as in what is already decided by the parties in the arbitration agreement.
Yes, ma'am. What can be done if one party ignores the arbitrator agreement?
I mean, there is no such thing as arbitrator agreement. Arbitration agreement, yes. You cannot do that, because party autonomy takes precedence, supersedes everything in arbitration. Even it supersedes the court. Now, what happens when the matter moves to before the court, whether it's for the appointment of arbitrator or whether it's jurisdiction, the court first looks into your arbitration agreement only. The court first decides whether there exists an arbitration agreement, because if there will be no arbitration agreement, then you do not have the power to move to the court. If you don't have an arbitration agreement, then you have to take another recourse. You have to take another legal remedy, whether it will be civil or any debt recovery, whatever. But if you have an arbitration agreement, then you will be moving the court under that particular agreement. So the court will first move to your agreement. It will first interpret your agreement. It will first decide the existence and validity of your agreement. So if you ignore your agreement and move to the court will bring you back to your agreement. So you cannot ignore it.
Ma'am, there is one question from Shivangi Rajput. She is asking, is it any different if the arbitration goes in arbitral institutions, like it is more speedy?
Okay, that's a good question, Shivangi. See, there are two types of arbitrations. One is ad hoc and the other is institutional arbitrations. Now, the institutional arbitrations are basically regularized, I'll say more regularized than ad hoc arbitrations because they're more systematic. Every institution has a system already in place that you will first send in a request for the arbitration, then the pleadings will be filed, and a time, the arbitral institutions have fixed their times. And the most important thing that makes arbitral institutions a bit better than ad hoc arbitrations are that all arbitral institutions have their rules, their arbitration rules. Those are procedural rules. Now, those rules are very well defined. Those rules are defined for very small specific things, for timings, for pleadings, for contacting the who's going to be the arbitrator, how is he going to be appointed. Every procedure is very well defined, and the time limit is there, and the time limit is given in all the small procedures that these rules have. That is missing in the ad hoc arbitration. The ad hoc arbitrator generally takes course of the CPC and Evidence Act, but the arbitral institutions take course of their arbitral rules. I wouldn't say it's very speedier than ad hoc, but it can be. Yes, there is a possibility.
Hope, Shivangi, you get your answer. Now we are taking the Q&A for 2 more minutes. If anyone has any queries, you can either unmute yourself and ask, or you can put your question in the chat box.
Res judicata applies to arbitration. Yes, it does applies to arbitration, but only like we said, who decides first. So that is one thing that you have to consider. And there's another thing that if the parties agree that you cannot these are the things that we rule out in their agreement, then it will not apply. And if you have already approached a civil court but you had an arbitration agreement, then no, it cannot be.
I hope, Anshika, you get your answer. I hope all the answers are all the questions are answered. There is an announcement for the students that the link for tomorrow's session will be shared in your respected groups. Kindly join the session on time tomorrow. If you had any questions or any doubts, you can either WhatsApp us or you can take these questions on the next session. Thank you. At last, I would like to proceed with vote of thanks. I, Diksha Kuchra, on behalf of Department of Law, Prestige, would like to extend my heartfelt gratitude to Ms. Roopdeep Sahani ma'am for taking out time for her busy schedule and enlightening us with such an enriching session. Thank you all.
Thank you so much, everybody, for coming in and participating. And I hope you guys enjoyed. And I mostly hope that you guys understood the concepts, because these are very important if you have to pursue arbitration in the future. And you can always email me or contact me on LinkedIn if you have any questions or queries. And if you would like to have these slides, you can let Diksha or me know and I'll share it with her. Thank you so much, everybody. Thank you, Diksha. Thank you, Shubham. See you tomorrow, guys.
Thank you, ma'am. Thank you for such an informative session.
Thank you. Thank you.